John and Carolyn are gone, so I'm the substitute, and I'm here to introduce Karen Kedrowski, who's with the Carrie Chapman Catt Center, and she's going to talk to us about the ERA, which we've all heard about forever, and nothing has ever been done. So she'll enlighten us today. Thank you.
Good evening, and thank you for coming out tonight. I'm going to not stand behind this podium because it's obviously built for someone who's about 7'8", and I am not. So yes, thank you, Paula, for that kind introduction. And I'm here to talk about the Equal Rights Amendment, which is actually celebrating its 100th birthday this year in 2023. And its history is actually really interesting and continues to evolve. So we will talk about that as well. So I love to start with this public opinion poll from the National Opinion Research Center, which is at the University of Chicago. And in 2020, they asked Americans, as far as you know, does the Constitution guarantee equal rights for women and men under the law or not? And 72% of the people in the survey answered yes, which means that 72% of the respondents were incorrect. The Constitution does not guarantee equal rights for men and women. What is actually more accurate is this statement by the late Associate Supreme Court Justice Antonin Scalia, which he says certainly the Constitution does not require discrimination on the basis of sex. The only issue is whether it prohibits it, and it doesn't, right? So, how did we get here? When we look for the words sex or male or female or gender in the Constitution, it's again a rather interesting history. So up until 1868, when the 14th Amendment was added to the Constitution only had gender-neutral nouns and pronouns in it. Words like electors and citizens and representatives and senators. So there was nothing that specified that these people were either male or female, or in today's nomenclature, non-binary, right? It was not until the 14th Amendment was added to the Constitution. Now, the 14th Amendment is really long, and we know it best for the Due Process Clause and the Equal Protection Clauses, which have been really, really important. But buried in there is also a clause about voting rights. And what it says is that if a state does not allow a sufficient proportion of its male citizens to vote, it can lose representation in the U.S. House of Representatives. This so enraged suffragists in the 1860s that they wanted to oppose the 14th Amendment because it meant that the 15th Amendment would apply to African American men only, which gives voting rights to African American men. And Elizabeth Cady Stanton said at the time, if we put the word male in the Constitution, it'll be 100 years before we get it out. She's wrong. It's been 150 years and it's still there. It is still in the Constitution. So the only place where we see the word sex is in the 19th Amendment, which is often referred to as the Woman's Suffrage Amendment. What the 19th Amendment really does is remove sex as a reason for states to deny voting rights to someone. So they can still use a number of other things like felony convictions or residency and so forth, but they can't use sex, right? So that's where the word sex shows up. But the words woman, women, female do not appear anywhere in the Constitution. And so this led to an open question, which was especially, but not only, because of the word male in the 14th Amendment, it led to a real question as to whether or not the protections of the Constitution actually applied to women, specifically the 14th Amendment's protections of due process and equal protection of the laws. It was not until 1976, I am not lisping, I am not mistaken, it was 1976 that in the Supreme Court case, Craig versus Boren, that the Supreme Court ruled that the 14th Amendment to the Constitution actually applied to women. Interestingly enough, Craig versus Warren was about males drinking beer. So if you'd like to know more about that, save it for the Q&A. So how do we solve this problem? One solution to this problem about women being relatively missing from the Constitution was the Equal Rights Amendment. So after the suffrage amendment, the 19th Amendment was added to the Constitution in 1920, a lot of suffragists had to figure out what they were going to do next, right? So some of them, like Lucy Burns, retired. Carrie Chapman Catt devoted the next 20 years of her life to the peace movement. But Alice Paul, who was the head of the National Women's Party, decided to focus on equal rights. She wanted another constitutional amendment which would make women fully equal within the Constitution. And so she started to work on an amendment. She drafted this original language. Men and women shall have equal rights throughout the United States and every place in its jurisdiction. And it was introduced for the first time in 1923. It was introduced in this form in every Congress until 1943. In 1943, the language was changed to what we are familiar with today, which has to do that there will be no discrimination on the basis of sex. Okay, so the Equal Rights Amendment debate between the 1920s and the 1950s or so was very different from what we would see today or even what we saw in the late 70s. What you saw is that there was a real mixture of liberals and conservatives who favored the Equal Rights Amendment and those liberals and conservatives both who opposed the Equal Rights Amendment. So a lot of what were called social feminists like Jane Addams and Flora Dunlap from Des Moines, who really wanted to work for the betterment of communities. They sought labor reforms. They were part of the Settlement House movement. They actually opposed the Equal Rights Amendment. Frankly, so did Eleanor Roosevelt and Carrie Chapman Catt, because they saw that this legal equality would erode a lot of the protective legislation that they had worked so hard to pass for women. Protective legislation like minimum wage laws, mandatory breaks, maximum work hours, right? These were all labor reforms that are part of our labor law today that were originally passed for women. On the other side, you had a number of liberals or feminists like Alice Paul who wanted this sort of principle of equality, saying that legal equality would be so important that it would actually supersede any of these, or make up for any losses from this protective legislation. But you also saw that there were conservative interests who really liked the ERA, like business interests. Why would business interests like the ERA? Because with the protective labor legislation, it made women more expensive to hire. Right? Sometimes more expensive than men, but also more expensive than if you simply didn't have those regulations in place, right? They could work longer, you could pay them less. So business interests were all over the ERA, and they liked it very much. So it was a real unusual mixture of liberals and conservatives that sort of sat on either side of the debate. So then we get into the 1960s, and with the 1960s and into the 1970s, we see the development of what's called the second wave of American feminism. So the first wave was suffrage. The second wave was stimulated really by two key events. One was President Kennedy's Commission on the Status of Women, which was actually led by a major, like the Secretary of Labor, or the Secretary of the Women's Office in the Labor Department, who opposed the Equal Rights Amendment. And so they wanted to propose a number of other legislative initiatives to kind of take the wind out of the ERA's sails. They failed. What happened is that they pointed out, and you can actually see this report online, it's called The American Woman. They pointed out so many areas of inequality in education, in retirement, in employment, that women were really an underutilized resource and source of wealth in the nation. And it led to some critical legislation like the Equal Pay Act, but it also really kind of stimulated this new feminist consciousness. In addition, at the same time, Betty Friedan wrote and published her book, The Feminine Mystique, in which she talks about the problem that has no name. Well, that problem was this feeling of being sort of disaffected and unhappy, especially for educated middle-class women, think suburbia, Levittown, that kind of thing, where the social messages that they had heard their whole lives were that they were supposed to be completely fulfilled with their lives as homemakers and mothers. And while many women were very happy in those roles, what Betty Friedan was capitalized and articulated a problem amongst the women who were not. And so that led to this sort of burgeoning feminist consciousness. And we see that this actually led to about 20 years of significant activity. There's first legislative activity to remove barriers to education and employment, so legislation like Title IX and so forth. And then there's also judicial activity through primarily the American Civil Liberties Union, the National Women's Law Project. It was at this time that Ruth Bader Ginsburg headed the Women's Rights Project in the ACLU, and she argued numerous cases before the Supreme Court to bring down sex discrimination. In fact, in some cases, she was arguing more than one case a day before the Supreme Court. So if you listen to the, read the transcripts or listen to the recordings, they will say, well, this afternoon, aren't you coming in on another case? And, she would end up having to respond to that. So we see here all of these major achievements that were really a product of the second wave of feminism. In addition, we also see that the ERA finally passes out of Congress in 1972. And this was as the result of the efforts of the woman pictured here, Martha Griffiths, who was a member of the House of Representatives from Michigan. And Martha Griffiths was a relatively senior member of the House. She was one of literally, 10 or something members of women members in the House of Representatives. And she was frustrated because the Equal Rights Amendment was bottled up in the House Judiciary Committee. The chair of the House Judiciary Committee was named Emanuel Seller. He was a Democrat from New York State, and he was definitely an ally of labor. And labor unions had traditionally opposed the ERA, and he hadn't really figured out that the labor unions were kind of getting mushy on the issue. So he just absolutely said no. He wouldn't even bring it up for hearings or debate or anything. So if he said no, it wasn't going anywhere. Well, Martha Griffith used a legislative technique called a discharge petition. A discharge petition is a way to bring a piece of legislation to the floor of the House without going through the committee process. It requires a majority of the House members to sign the discharge petition with their own names, right? And this is sure to, shall we say gently, annoy the chair of the committee that they're making an end run around. So it's a risky move because someday these members might want their own legislation to come through this committee. And if they have angered the committee chair, they could be in trouble down the line. Nonetheless, Martha Griffith got 17 of her colleagues, because she signed it as well, so she got 218 signatures, which brought the ERA to the floor, and it passed overwhelmingly. This is the problem, though. The Senate didn't act. So the next year, it had to be reintroduced, but at this point, Emanuel Seller agreed to hold hearings and to put the ERA through the normal legislative process because he realized it was so popular. And that year, then, Birch Bayh of Indiana managed to shepherd the ERA through the Senate as well. And so this became the language. This is the same language that had been used from 1943 on. Equality of rights under the law shall not be denied or abridged by the United States or by any state on the account of sex. That's the first article. The second article is Congress shall have the power to enforce by appropriate legislation the provisions of this article. So at this point, the ERA goes to the states. And initially, the states are in a race to ratify the amendment to the Constitution. The first state that ratifies is Hawaii, 20 minutes after the Senate vote, right? This is through the magic of telecommunications. There's somebody sitting on the phone between the U.S. Senate and the Hawaiian legislature going, okay, you can vote now. And Hawaii passed it. And I mean, they just come in rapid succession afterwards. Iowa is the fourth state that ratifies in 1972. And so in 1972, in 1972, we see that 20 states have ratified. In 1973, we're up to 27 states. And then the ratifications slow down. So by the time we get to 1977, 35 states have ratified, and it gets stuck there at 35. So that's 3 states short of the 38 that are needed. The initial period for ratification in the accompanying legislation for the ERA was 7 years. So the ERA expired in 1979. And by this time, 5 states, including our neighbors, South Dakota and Nebraska, had rescinded their ratification, saying, oh no, we didn't mean that. We don't want to do that anymore. So Congress at this point passed a 3-year extension, which expired in 1982. The extension itself was very controversial. There was a lot of questions about whether or not it was even legal or legit, but it really didn't matter because during those last 3 years, not a single additional state had ratified. So what happened? Well, what happened is Phyllis Schlafly. So first of all, to talk about who favored the Equal Rights Amendment, there was just an absolutely overwhelming number of interest groups and professional associations, powerful interests within the United States who favored it. So the primary organization was ERA America, which was really a coalition of groups, but every single major organization for women and girls, the League of Women Voters, the AAUW, the National Women's Political Caucus, the Republican Women's Federation, the Democratic Women, the Girl Scouts, right? Everyone that you can think of favored the Equal Rights Amendment. In addition, you also had the Catholic Health Association and nuns groups in defiance of their bishops who favored the Equal Rights Amendment. Every professional organization, so the business and professional women, like lawyers associations, women medical associations, all of them favored the Equal Rights Amendment. Both the Democratic and the Republican parties had planks in their national platforms for the Equal Rights Amendment. The Republicans had it starting in 1940 and the Democrats in 1944. So this was a long-standing thing. You had 3 first ladies who actively campaigned on behalf of the Equal Rights Amendment, 2 Republicans and 1 Democrat, and there was always a majority of support in public opinion polls, somewhere between 55 and 65% of the public, right? So it should have passed, right? It absolutely should have passed. But it didn't because Phyllis Schlafly, who was actually a national figure before she got involved in the Equal Rights Amendment, made it her cause célèbre. And she created the organization Stop ERA. Stop meaning stop taking our privileges. And she was really able to capitalize on a lot of the kind of uncertainty or even fear that a number of conservative women, especially housewives, had about the feminist movement in general and the ERA specifically. So they felt that people did not value, especially when they were told, like, why don't you go out and get a job, that their choices of being mothers and homemakers were questioned and not valued by feminists. But also that they were very fearful. They were fearful of losing alimony, right? They had entered a social contract with their husbands, where their husbands would support them, they would take care of the home and the family, right? But many of these women married very young. They may never have been in the workforce. They did not have any marketable skills. They did not have educations. So maybe they had a high school diploma, maybe they didn't even have that. So if they were abandoned because this social contract with them and their husbands no longer existed, then they could be left utterly bereft, right? And unable. So they were very fearful that if there was all this equality, that a lot of the legal protections that they saw as in their interest, right, laws such as alimony and child support and the difficulty of getting divorce and so forth would actually protect them, and that those would be gone. So Schlafly was able to really capitalize on those fears, but then she also managed to put together a very interesting coalition of individuals, including religious leaders, so the Catholic bishops, for example, a lot of evangelical leaders, and this was just as the new right is starting to get organized in American politics, and the Church of Latter-day Saints, or what were known then as the Mormons. Schlafly herself had a lot of ties to the John Birch Society and other far-right organizations, so they became organized and did a lot of fundraising for Stop ERA to give them the money that they needed to operate. There were individual military leaders who also became involved in the cause. The U.S. military, the Department of Defense, was officially neutral, but there were retired leaders who raised questions about what this would mean for military readiness and so forth. And any other sort of vague traditional families. We do know that members of the KKK were involved in this movement. So it was not that the KKK joined this coalition, but there were people who were hired to provide security, who were known to be active in the KKK in certain states. The primary advocate in Mississippi was actually the wife of the Grand Dragon of the KKK, and there was a lot of talk about maintaining our traditions and our way of life, so those became kind of coded language for a whole variety of unpleasant things, shall we say. So what was the debate like, right? So those who were in favor of the Equal Rights Amendment actually had a pretty difficult time, because what they were talking about were principles, right? Sort of vague principles. So one of the most important things that the Equal Rights Amendment would have done and would do today is that it would lift sex discrimination and place it under the judicial the judicial examination of strict scrutiny, that criteria, right, Right now, sex discrimination is subject to what is called intermediate scrutiny. Racial discrimination, religious discrimination, discrimination on the basis of national origin, all fall under strict scrutiny, which is the highest level of scrutiny that the court can use. In other words, it says if there is apparent discrimination on the basis of race, there's really almost no justification for why this can exist, right? Sex discrimination falls under intermediate scrutiny, which was made up, right? But it says that sometimes sex discrimination is okay if there is a compelling government interest in having that sex discrimination. What does that mean? Whatever the court says it is. But it means that sometimes sex discrimination is okay, right? So it's not that presumption of no, this is a bad thing that you have in the cases of racial or religious discrimination. It would definitely provide constitutional protection for all of that legislation that had been passed in the 60s and 70s about sex discrimination. But these kinds of things are really kind of fuzzy. And for a lot of working class women, it didn't resonate because they didn't really see how this was going to benefit them. So the advocates started talking about the gender wage gap. And the gender wage gap in 1972 was 59 cents. And what that means is that a woman's median income was 59% of a man's median income. So a woman earned 59 cents for every dollar that a man earned. And they attributed this all to sex discrimination. Some of it was due to sex discrimination, without question, but not all of it. And in Q&A, I'm willing to talk about the many, many things that go into the gender wage gap. And then the question of abortion came along. So, of course, the ERA was passed in 1972. Roe versus Wade was decided in 1973. And even though these two came about through completely different processes, judicial versus legislative, feminists generally endorsed both of them. So people who opposed abortion, which became this incredibly divisive issue, then became opponents of the Equal Rights Amendment. The two became completely conflated. And the reason that they became completely conflated has to do with, again, the opponents. So Phyllis Schlafly, who was a devout Catholic and very opposed to abortion, among other things, argued forcefully that this would provide a constitutional protection of abortion. And for conservatives, this became something of a clarion call. Proponents were divided on the question. Some of them said, why, yes, it will, and this is a good thing. And some said, oh no, this is a totally separate issue. So the proponents' message was a mess. The opponents' message was very clear. In addition, they managed to have a whole bunch of other really scary scenarios. So they talked about unisex bathrooms. They talked about unisex locker rooms, unisex gyms, unisex prisons, and in all of these, men would be lurking in them, waiting to assault women, unsuspecting women. They also said that it would lead to gay marriage and homosexual rights, like the right to be able to teach in public schools and adopt children, and to inherit your spouse's social security benefits, and all sorts of crazy things that they believe should be reserved to heterosexual married couples. They also did have some legal issues. One was that it wasn't needed because there was all this great legislation that had been passed, so why do you need a constitutional amendment? They also capitalized on that second phrase about Congress shall have the power to enforce this law. They talked about this being a federal government overreach. And what that really was coded language for racial integration. Because in the South, federal overreach was associated with mandatory desegregation of schools, mandatory desegregation of public venues and restaurants and everything, neighborhoods and so forth. So in the South, that again had connotations that it did not carry in other places. They also talked about the fact that women would be drafted and women would be in combat roles. Now, at the time, this is right towards the end of the Vietnam War. The Vietnam War was very unpopular. The draft was really unpopular. There was growing understanding about how unfair the draft was in terms of people who could get out of it versus those who had no resources to be able to work the system, right? And so by talking about women having to be drafted, they talked about, they had little babies coming to state legislatures with signs on their cradles saying, "Don't send my mommy to war." But also they had military personnel who talked about unit readiness, and unit cohesion, that in fact having women in combat roles would mean that the soldiers wouldn't fight as well. And they were essentially making chivalric arguments like, well, they won't want to be, if they're in a foxhole with a woman, they're going to do everything to protect her and place, and they won't want to put her in danger. And, they had all these wild scenarios. And frankly, the proponents did not have a very good response to that. The public was not really ready to think about women being in combat roles or being in the military. Okay, so we get to 1982 and everyone believes that the ERA is dead, proponents and opponents. And so what we begin to see is that feminists and opponents are kind of focusing on different things. So there's a number of efforts, including in Iowa, to pass state-level ERAs and add ERAs to state constitutions. There's a focus on more local programs, like developing domestic violence shelters, state-level reforms of divorce and sexual assault laws to make those more sweeping and more inclusive. There's some pretty significant legislation that is passed, such as the Violence Against Women Act and the Family and Medical Leave Act. And we see women continuing to make inroads in education and professions and even some in elective office. So really, by the time we get to the 1990s, women are a majority of the students on college campuses, and they are earning a majority of the degrees at the associates, the bachelor's, and the master's level by this time. And the gender pay gap has continued to narrow. So by the time we get to the 1990s, or by 2000, it's at 71 cents, which is a pretty significant difference from 59 cents. So, and the conservatives are focusing on abortion, they're talking about communism, they're doing all those things. Okay, and then along comes the Madison Amendment, otherwise known as the 27th Amendment. And the text of that amendment reads, "No law varying the compensation for the services of the senators and representatives shall take effect until an election of the representatives shall have intervened." So what does this have to do with women in politics? What does this have to do with equal rights? Nothing. Absolutely nothing, right? But this is the interesting thing that most people don't know, because if you think back to your elementary school civics, how many amendments are there in the Bill of Rights? 10, right. Well, here's the dirty little secret. There were actually 12 introduced in that package of the Bill of Rights. So, but only 10 of them were ratified by 1791. And 2 were just sort of hanging out there in the ether. So here's another dirty little secret. All these people who talk about the sacredness of the First Amendment? The First Amendment was third. So yeah, okay. So now you have your random pieces of trivia to take home. I tried to give you some. Okay, so, but one of them was this one, right? So what happens is that there's a young man at the University of Texas who takes a political science class, right? There's always going to be trouble that comes from somebody taking a political science class, right? So, and he also happens to be working for the Texas state legislature. And he wants to research the Equal Rights Amendment. He decides that he wants to talk and make a case that the extension to 1982 is unconstitutional. And in the process of doing the research, he stumbles across the Madison Amendment. And he goes, wait a minute, this could still be ratified. Now at this time, there were a lot of scandals going on. There was the House banking scandal at the time. There were some very controversial pay increases among members of Congress voting themselves hefty increases. This was when Dan Rostenkowski went to jail for, cashing in his frank and his postage and pocketing the money and stuff. So all of that stuff was going on. And so Gregory Watson wrote a paper saying the Madison Amendment is still before the states and could still be ratified. And his teacher said, nah, no way. Gave him a C. And he said, oh, I'm going to show her. And so he worked to get Texas to ratify. And then he worked with his member of the legislature to start shopping this to other states. And he got the amendment ratified. So you can see here the ratification history. It had 6 states by 1791, 2 more in one in the 19th century and one in 1977, and then the rest of them happened by 1992, right? 202 years was the ratification history of this amendment, right? By the way, the teacher changed his grade and gave him an A. So this led to what is called the 3-state strategy, or I like to think about it as the 3 more state strategy. So this was articulated in a law review article in the William and Mary Journal of Women in the Law, published in 1997, why the ERA remains legally viable and properly before the states. And they argue, again, it's these college professors, right, publishing and what are not going to be the kinds of things you'll find in your doctor's office, right? A law review, right, argues that the Madison Amendment, this amendment about congressional pay, demonstrates that there is no time limit to ratify constitutional amendments, unless that language is in the amendment itself, right? Now for the ERA, it was in the accompanying resolution, not in the amendment. So they argue that the ERA is still before the states, and they further argue that Article 5 of the Constitution, which lays out the amending process, does not say anything at all about time limits, completely silent on the issue, and furthermore they argue that the rescissions are illegal. So this argument says the ERA is still viable and it has 35 ratifications. So all we need are 3 more states, and lo and behold, we have the ERA, right? Well, this led to a national effort to get 3 more states. Now, this bypassed Iowa because Iowa was already one of the 35, right? And the advocates focused on those states that they thought had the best shot of ratifying. So they ignored really the Deep South, and they were successful. Nevada ratified in 2017, Illinois in 2018, and Virginia in 2020. Now, while all of this is going on, North Dakota gets nervous, and its state legislature then passes a resolution that says our ratification was only good until 1979. So it was essentially a rescission, right? So at this point, we're in 2020, right? This is like in constitutional time yesterday, right? So we are in the Department of Justice in January of 2020 when they are aware that Virginia is about to ratify the Trump administration's Department of Justice issues a guidance, a memo that now the National Archivist is the person who collects all of the government's paperwork, including ratifications, right? That's the job of the archivist. And so the Trump administration directed the archivist to not accept Virginia's ratification, arguing that the time limit had passed. So Virginia could do whatever it was going to do, but it wasn't going to matter, right? Okay, so needless to say, there was a fair amount of pressure on the Biden administration to rescind this Trump administration DOJ memo. The DOJ does not like to contradict itself. So there was a lot of pushback from the professionals in that department to do something else, right? So they issued a clarification memo in 2022, which says the National Archivist shouldn't do this, but if Congress just passes a resolution, the Congress removing the time limit, then the Congress can direct the National Archivist to accept these late ratifications. So it's in Congress's lap, as it were, right? And Biden said the day after this memo clarification was lifted, that if Congress passed a resolution, a law, saying that it was going to lift the time limit of the ERA, he would immediately sign it so that the archivist could add these last 3 ratifications to the Constitution. Okay. So, now there are multiple things that are happening in Congress. There are members of Congress who are still reintroducing the Equal Rights Amendment as a constitutional amendment. But now there are members of Congress who every session are introducing resolutions to say that the time limit has been banned. So in this year, it was Senate Joint Resolution 4, sponsored by Ben Cardin of Maryland, and House Joint Resolution 25, sponsored by Ayanna Pressley of Massachusetts, and that this would remove the time limit for the ERA. So in February, the Senate Judiciary Committee held hearings on the ERA. The first time in 50 years that there had been a congressional hearing on the ERA. And the Senate then brought up the ERA for a vote in April. And the ERA resolution was filibustered. There were 3 attempts to vote cloture. The final cloture vote fell short of the 60 votes needed to stop the filibuster. So even though the vote was 51 in favor, 47 against, the ERA time limit resolution fails. Now, of course, there was also a 0% chance that the Republican-controlled House was going to bring this up in this session of Congress. In addition, Senator Cindy Hyde-Smith of Mississippi also introduced her own ERA resolution saying that the ERA was dead. And at the same time, Virginia, Illinois, and Nevada decided to sue the federal government to try and get the National Archivist to accept their ratification. So this case became initially the Commonwealth of Virginia versus Fierro. So Commonwealth, why is Virginia first? Because the letter C is first in the alphabet. And Fierro was at the time the National Archivist. The U.S. District Court ruled against the states, saying that the ERA's time had come and gone. And so they appealed. In the process of the appeals, Virginia withdraws because they get a new attorney general who's a Republican and he doesn't like it. So Virginia drops out of the case. Fiorio retires. So the case now becomes Illinois versus Fiorio. They still kept Fiorio's name on it. I'm not quite sure why. But then into February 28th, the U.S. Court of Appeals then also denied this and said that the ERA is dead. So what are the arguments? I watched the arguments that were made in the Senate hearing, and it was just remarkable how much they were the same as what had happened in 1970. But I think another thing that is really fascinating here is that so many of the arguments against the Equal Rights Amendment that were used in the 70s are now moot points, right? So talking about how the ERA would eliminate the women and the mother's advantage in child care or child custody and alimony, those divorce reform laws are already gone and in place. Women are now allowed into combat positions. We do not have a draft. Gay marriage has been legalized. We have unisex bathrooms, right? They're called family restrooms, right? But we have them, right? And the labor laws, there are very few single-sex protective labor laws in place. Really, all the protective legislation that exists still is for all workers. If the ERA was enacted, women would have to register for the selective service, i.e. the draft. And if the draft was ever reinstated, women would be drafted along with men. Would it provide constitutional protections for gays and lesbians? Yes, it would, absolutely. And would it provide a constitutional protection for abortion? Probably yes. Probably yes. In terms of the proponents, would it eliminate the gender pay gap? Not entirely. It would eliminate some of it. It would be like another tool in the toolbox for somebody who believed that they were being discriminated against. It would certainly elevate sex discrimination to the level of strict scrutiny, and it would ensure that courts would not overturn legislation or other legal precedents that have affected or eliminated sex discrimination. So it would provide sort of a constitutional backup. And coming back to public opinion, 73% of Americans strongly or somewhat favor adding an Equal Rights Amendment to the Constitution, so it still enjoys, well, this is even more support than what it had in the 1970s. Most people believe that it would have a positive impact on the country overall, and especially for women in the nation. And I thank you for your kind attention. What are your questions? Yes, Susie.
If people are adjusted after the Constitution, do you think that traditional families would start to attack other people because of it?
Okay.
Or not?
So the question is if the ERA is passed to the Constitution, would there be some sort of backlash against traditional families? And I think no. I think that the traditional family structure of mom and dad and kids is always going to exist. But I think that we would also see further constitutional protection of what we might call alternative family structures. Where you have two moms and two dads, or other things. Single parents, shared custody, those kinds of arrangements. So I don't think that would disappear. I don't think any of the sort of traditional structures that we would have would disappear. I think that there would just be constitutional protections for other vulnerable groups. So. Anybody want to hear about the gender wage gap? Okay, so the gender wage gap is actually a function of a number of different things. So Phyllis Schlafly used to say that the reason that there was a gender wage gap was not because of discrimination, but because of women's choices. And she was partially right. So in many, many families, we find that women are willing to put their career secondarily to their husbands. So what does that mean? So much of our work structure and our rewards systems and our retirement systems are based on what's called the male work pattern. And this is the idea that, you go to school, you get trained in your trade or your profession, and then you go to work for one company and you work for them for 35 or 40 years. You get regular pay increases, you get regular promotions, and then you retire. You get a gold watch and a really nice pension. But if you deviate from that pattern, then things start to fall apart, right? So what's one deviation? You leave the workforce to take care of your children. Right? You do a lot of job switching because as your professional husband might get promotions that have you moving from location to location, the husband doesn't lose anything, in fact, gains something, but the trailing spouse, would leave a job and then find another job. Well, in the process of doing that, they might lose seniority, they would have to go back to lower wages. There would be breaks in their employment, but as the family is moving and while they're looking for a new job and things like that. Women are more likely to work part-time, especially as a way of being able to balance the home and family. And women also take breaks from the workforce, are more likely to do that, to take care of children. But we also see that women are more likely to accept jobs in the public sector. So let's say you've got two accountants, right? Same training, same, some skill set and so forth. Women, and frankly, people of color, are more likely to take that and go become an accountant for a government, local, state, or federal, versus the private sector. Why? Because there's job protection, right? There's greater job protection in government employment. Yes?
I would also argue that there is greater acceptance in the governmental workplace.
Yes.
To have women and people of color.
I would absolutely agree. And in fact, when you look at the private sector versus various government agencies, the government has a far more diverse workforce. And for another reason is that the government does not negotiate salaries, right? You come in and this is what you're paid, and that's the same thing as the person sitting next to you who comes in with the same qualifications on the same day as you, right? So without that negotiation, you also don't have a gender pay gap that comes from women's reluctance to negotiate. But that's very common in the private sector. So you can account for all of these different variables, and there is still a portion of the gender wage gap that is attributable to discrimination. And it's narrower. And the group that is least likely to experience a gender pay gap, are college-educated, single, white women at the point of graduation. The gender wage gap for that group is about 7 cents. It's still there, but it's about 7 cents. And then as you look at, as women who have been in the workforce longer, i.e. they're older, that wage gap just continues to grow. And of course, all of this has implications for retirement, Social Security benefits, family, financial stability.
My question is, what now? There must not be the end, because I've been signing petitions.
Right, yeah, absolutely.
So what's the next?
Okay, so look at what theoretically could happen is that the Senate could take up the Equal Rights Amendment again. So when it was clear that the cloture vote was going to fail, Charles Schumer, the majority leader, or the Democratic leader in the Senate, switched his vote so he would be on the prevailing side, which would allow him to bring it up for a vote again. That is, if they felt that there were 60 votes in the Senate. And it is theoretically possible that the House could bring up the bill or the resolution. It would take an act of the supreme being of your choice, because it could theoretically be done with a discharge petition, but you would need all the Democrats to sign plus about 4 Republicans. And one thing to be said about the House of Representatives is that the two parties in the House of Representatives are very, very, very disciplined. So it would be tough to find those 4. Now, having said that, we're going to have an election in just a few months, right? 15 months from now or so. If there is a Democratic majority in both chambers, it is possible that the resolutions could be passed at that point. And then, of course, there's always the idea that the amendment would be reintroduced and you would just start the process over. I think that that's highly unlikely because you need the supermajority, 2/3 votes in the House and the Senate. But it's also based on the assumption that every state that ratified the ERA in the 70s would ratify it again today, and I think that's a very, very questionable assumption.
It's very intriguing that it's such a political divide. In other words, it's become this political issue. And you've got 2 different parties and 2 different attitudes.
Yeah,
It
exactly.
seems very strange.
Yeah, and that sort really happened by 1980.
It already did.
Yeah, by 1980. So in 1980, the Republican Party dropped its support for the Equal Rights Amendment from its party platform. Ronald Reagan was strongly against it. And at that point, we really see that we start to see the rise of the religious right. And that's a combination of really conservative Catholics who are motivated primarily by the abortion issue, but also just the religious right that didn't like what they really saw as an intrusion on traditional values. And that included, feminism, it included gay rights, it included civil rights for people of color, and one of the most motivating factors of the religious right was actually not abortion, even though they talk about it all the time now, right? What it was the Supreme Court decisions that said that private organizations that discriminated on the basis of race would lose their tax-exempt status, right? So this was all-white golf clubs. This were segregation schools. This was Bob Jones University. All of those. And that became this notion that there was government intrusion trampling on our way of life and so forth. And then, you add in Anita Bryant and orange juice, and you got a whole other thing going.
Where does sexual harassment fit into this?
Oh, that's a great question. Yeah, so sexual harassment is kind of a different kettle of fish. Sexual harassment as a concept was developed through the judiciary, and then later in law, like with the Violence Against Women Act and so forth. So, Carol Gillian, a feminist theorist and a law professor, developed this notion of sexual harassment based on the jurisprudence of racial harassment. So she looked at court cases that had ruled against, say, employers or institutions for harassing people on the basis of race. And she developed some analogous principles for bringing essentially civil rights cases to the EEOC, the Equal Employment Opportunity Commission, saying that there was a similar thing for sex, right? And it took a while, but it worked. And by the time we get actually to 1998, the Supreme Court hears a whole family of sexual harassment cases that really define the parameters and the different kinds of sexual harassment, but also what the expectations of the employers are and where their employer and individual liability is. And then those later have been now codified into law. So sexual harassment kind of developed as one of those things sort of after the ERA, you know, and the courts have very clearly defined two types of sexual harassment. So one is quid pro quo sexual harassment, which says, you know, have sex with me and you'll get a promotion, or have sex with me or I'll fire you, right? The other one is what's called the hostile environment sexual harassment. And a hostile environment does not have this notion of a power relationship. So quid pro quo, it has to be somebody who can make that threat stick, right? So there has to be some sort of a power relationship. Hostile environment doesn't have that, right? It can just be your co-workers that are at your same level, but if they harass you so badly that you're miserable at work, that creates what's called a hostile environment. So some of the cases that brought this up were a woman that worked in construction who was locked inside the porta potty and they wouldn't let her out, which is toxic.
Yeah.
Pouring sugar into somebody's gas tank of their car, taking out safety features of heavy equipment that then made the equipment dangerous to use and could have badly injured or killed someone. So these are pretty egregious. You know, it wasn't just grabbing or, you know, off-color jokes or anything. These were actually very serious. Yeah.
Because they had to prove it's because.
Yeah, exactly. And they did it because it was a woman. And that was, and then one of the 1998 cases also very clearly defined sexual harassment as not being, it didn't have to be male on female or female on male, that it could be same sex. So that was an important advancement as well. Good question. All right, it's 8:02. So I want to thank you all for being a great audience. I'm happy to hang around and chit chat if you'd like, and thanks to our Facebook audience as well. So I really appreciate so many of you coming out tonight.